Good afternoon, everyone. And welcome to today's briefing on the civil rights standards for 20th century employment selection procedures. My name is Ariana Aboulafia, and I am the Policy Counsel for Disability Rights and Technology for the Center for Democracy and Technology. Brief visual description. I wear glasses. I have long, dark, curly hair. I am wearing a black shirt and a gray blazer. My colleagues and I are so glad that you've taken the time out of your day to join us. I'd like to cover a few housekeeping items before we turn to our program. We're providing live captioning for this webinar today, which can be accessed by clicking the CC button at the bottom of your screen. If you have questions, you can send those questions using the Q&A feature that's built into Zoom, also at the bottom of your screen, or by emailing them to questions@cdt.org. Both will be monitored, and questions will be featured during our Q&A window scheduled at the end of our program. Joining us today will be Henry Claypool, Technology and Disability Consultant for AAPD, Matt Scherer, the Senior Policy Counsel for Workers' Rights and Technology here at CDT, and Alexandra Reeve Gibbons, the President and CEO of CDT. And to kick us off officially, I'll turn it over now to Alex.
Wonderful. Thanks so much, Ariana. And thank you, everyone, for joining us. A brief visual description of myself. I am a blonde woman wearing a white tank top and a gold necklace on this hot, sunny day, dialing in from DC. We're really thrilled that you will join us on this session today because it covers an incredibly important issue. For an increasing number of people across the US and other countries, decisions about whether they're hired, promoted, or fired are increasingly influenced by employment decision tools, software whose use or inner workings are largely hidden from workers themselves. These tools can include everything from a resume scanning tool, which looks at keywords in an applicant's resume, online games, which purport to assess traits like an applicant's appetite for risk, or personality quizzes, which can ask questions like, do you agree with this statement? I often feel sad. Often these tools work by evaluating how applicants compare to existing employees in the hiring company. That's a dangerous approach. It can entrench existing inequalities in the workplace or assess workers based on factors that have little or nothing to do with the ability to perform the essential functions of a job. Disabled workers confronted with these tools face additional challenges because modern selection tools are often designed without regard to accessibility or accommodation rights under the Americans with Disabilities Act. Disabled workers may not be able to access gamified assessment tools or participate in automated video interviews at all, effectively forcing those workers to disclose their disability status just to participate in the hiring process. Tools that rely on personality testing or that score workers based on their facial expressions, physical movements, or vocal characteristics might have difficulty accurately assessing the abilities of workers with a wide range of disabilities. Civil rights, workers' rights, and tech policy groups have been sounding the alarm about the dangers of these tools. Yet algorithmic discrimination in employment still faces little to no accountability, in large part due to the lack of transparency to workers and regulators regarding where the tools are used and how they work. We're glad that regulators are starting to take notice. Last year, the Biden administration released the Blueprint for an AI Bill of Rights, which describes some of the risks of algorithmic decision-making tools and called for action. In turn, the Equal Employment Opportunity Commission and the Department of Labor have launched an initiative on the use of AI in employment decisions. The EEOC, Equal Employment Opportunity Commission, and the Justice Department have also issued guidance explicitly warning that the use of these tools may violate the Americans with Disabilities Act. Legislators at the federal, state, and local level are focusing on this issue as well as the broader discussion around algorithmic accountability too. And then in Europe, regulators are examining employment issues closely as they finalize negotiations on the European AI Act, which is being finalized this summer. But there's still a need to move on from high-level principles and warnings from regulators to concrete guidance for the companies that make these tools, for employers deciding whether and how to use them, and for workers who deserve to know their rights. For that reason, CDT is proud to have partnered with coalition partners to release the Civil Rights Standards for 21st Century Employment Selection Procedures. The partners who participated in drafting the standards are an exceptional group, and they show the importance of this issue. the American Association of People with Disabilities, the ACLU, Upturn, the Leadership Conference on Civil and Human Rights, and the National Women's Law Center. We're also proud to have received endorsements from the Autistic Self-Advocacy Network, the Bazelon Center for Mental Health Law, Color of Change, the National Employment Law Project, and others. The Civil Rights Standards set out recommendations for how to scrutinize and mitigate risks of discrimination in employment decision tools. They build on years of advocacy by our organizations for regulators to use their rulemaking, investigative, and enforcement authorities to address technology's role in hiring. We hope they'll inform some of the legislative and regulatory efforts currently underway. But even apart from that, they give concrete guidance to employers now about how to act responsibly in this space and do right by their workers. We also hope that it's useful for advocates across the country as we all together keep pushing for reforms. We're so glad to be joined today by some of our collaborators on the standards for a discussion about what they recommend and their role in the current employment landscape. I'll turn it over next to Matt Scherer, CDT's Senior Policy Counsel for Workers' Rights and Technology. Thanks again.
Thank you, Alex. Hi, I'm Matt Scherer, and I lead CDT's Workers' Rights Project, which focuses on the ways in which technology can both imperil and empower workers in the modern workplace and labor market. As a visual description, I'm a white male. I have brownish reddish hair, and I am wearing a gray dress shirt. And for today, we'd like to talk to you about the civil rights standards and give you some background on how they came into being, as well as what they go into in substance. So a key part of this project that I direct here at CDT is advocating for stronger oversight and enforcement against modern selection tools that can undermine workers' access to employment. That's what led us to partner with our sister organizations to create the civil rights standards. Next, you'll hear from Henry Claypool, a technology policy consultant for the American Association of People with Disabilities and a fellow here at CDT. Henry, you are up next.
Thanks, Matt. And a visual description. I am a white male with brown and slightly gray hair, wearing a blue shirt with a kind of patterned of, I guess, blue and orange dots. So first, I wanted to give you a little background on the American Association of People with Disabilities work on technology issues. In some of our work, we elevate how technology can be built using inclusive design principles and involving disabled people to highlight the role technology can play in addressing the barriers that members of our community face every day. We also know that when technology is built without awareness of these unique needs of disabled people, it can make it less useful, and in some cases, it perpetuates the disability discrimination too many of us deal with on a daily basis. Turning to today's topic and just the general trend of the exponential increase in the use of AI and other forms of data-driven innovation, we know developers and those using technology face some significant challenges. Because of the central role that data plays in automated algorithmic decision-making, disability presents some unique challenges. First, we are poorly represented in the data used by these technologies, which often leads to an inability to get reliable predictions from these tools. And second, even where we are included in the data, these tools are rarely designed with the capacity to identify the characteristics that disable people in the data. And as a result, technology often doesn't work well for people with disabilities. Unfortunately, AI tools and other data-driven technologies are rarely developed with the intent of ensuring that disabled people are not harmed. In response to these challenges faced by people with disabilities, including those with intersectional identities that incorporate characteristics of other protected classes, AAPD works with other civil rights organizations and civil society groups with expertise in technology policy to push back against the harms that emerge with the development and deployment of these data-dependent technologies. Complementary to our work on that is CDT and AAPD share a strong interest in building capacity to analyze technology policy using a disability rights lens. To that end, we are working together to create a space for disability rights and disability justice groups to come together and become even more engaged in shaping technology policy. Today's webinar shows how this work is being done in practice. Elevating the employment provisions of the ADA can protect people with disabilities and others from discrimination when automated selection procedures are used. This is just one example of the work that CDT and AAPD are doing together, highlighting the important role disability rights law plays in securing and protecting against discrimination. Also creates an opportunity for other disability rights and disability justice groups to find a way to get more involved in shaping the policy that governs the use of this technology. And also, this webinar is an important step in organizing interested parties to urge policymakers to adopt broad civil rights protections that employers use when they're using automated selection procedures to hire people. Next, I'll turn it over to Ariana, and she'll talk briefly about the policy background against which the standards were developed.
Thank you so much, Henry. For over 4 decades, employers and vendors have been relying heavily on the 1978 Uniform Guidelines for Employee Selection Procedures to inform how they can best avoid disparate impact or discrimination claims related to their use of employee selection procedures and tools. But these guidelines predate the Americans with Disabilities Act, and they don't consider the needs of disabled workers as well as the legal rights that those workers now enjoy under the ADA. In addition, these guidelines have not been updated to keep up with our understanding today of inequity in the job market generally, as well as how bias manifests in modern tech-driven hiring practices, issues that we have seen impact disabled workers. CDT has analyzed how algorithm-driven hiring tools can potentially violate the ADA because of how the tools are designed to be used and what criteria they measure, which can, in effect, screen out workers based on disability rather than on potential work performance. This is why we're glad that the EEOC and the Justice Department issued new technical assistance last year to guide employers to ensure that the algorithm-driven tools that they use in hiring are designed and developed to prevent disability discrimination. The technical assistance conveys that employers are responsible for the impacts of the hiring tools that they use, whether developed in-house or by a vendor, that employers must address risks of discrimination in these tools more proactively, and that employers must also ensure that these tools are narrowly designed to only measure ability to perform essential job functions. Although this assistance is non-binding, it marks an important acknowledgement of the rising importance of considering disability and policymaking surrounding these tools and practices moving forward. There is much more to be done to address technology's impacts on workers based upon disability, but also race, gender identity, sexual orientation, age, and religion, and to address impacts for the intersection of multiply marginalized identities. Still, while there have been some promising state and local level proposals for enforcement against algorithmic discrimination, we've seen other problematic proposals that might actually disincentivize employers and vendors from correcting algorithmic bias. This demonstrates even more so the need for guidance about the kind of notice and auditing requirements that would achieve true algorithmic accountability. And to this end, CDT, the ACLU, AAPD, Upturn, the Leadership Conference on Civil and Human Rights, and NWLC worked together to create the civil rights standards for 21st century employment selection procedures, a set of standards to lay out what notice workers should receive about the use of modern selection tools, what auditing measures and considerations would mitigate discrimination in those tools, and how to hold vendors and employers accountable for using discriminatory tools. I'll start by highlighting some of the ways in which modern selection tools can cause or contribute to discrimination. One issue is that these tools are often not offered in an accessible format, requiring workers to physically interact with devices in ways that may be difficult due to a disability. Another issue is the discriminatory criteria that these tools may be testing. For example, personality and aptitude assessments measure traits that are not always related to performing essential job functions, but that could be related to or impacted by a disability. For example, a tool may assess a candidate's quote unquote optimism, even though a job may not actually require someone to possess or demonstrate that trait. Such a tool might assign a lower score to a candidate with a particular mental health disability, which could prevent them from getting a job. Even if a personality or aptitude assessment does measure relevant traits, it derives data about personality traits or aptitudes in a different manner and context from how personality traits and aptitudes would be demonstrated while one performed the job itself. As another example, resume scanning tools derive the terms that they search for from attributes that employers claim to value. They can learn or be trained to disqualify resumes that then lack those terms. The tools can also fail to contextualize information on a worker's resume that does reflect their ability to perform a job, because tools only learn to recognize language that they are trained to process. The tools, for example, could disqualify resumes with employment gaps, which could be due to a medical leave, to a disability, or even to caregiving responsibilities. Also, interview analysis tools evaluate workers' responses to interview questions. Some also may analyze eye and facial movements, speech cadence, and tone of potential job candidates while they respond to interview questions. These all become data points to gauge a worker's trustworthiness, optimism, and other traits. But individuals with various disabilities that may be impacted by eye or facial movements or speech cadence, such as individuals who may have been impacted by strokes, may be unfairly screened out by these tools. And to come full circle and talk a bit more about the accommodation issue, these tools pose unique issues related to accommodations for disabled workers. For example, accommodations may have little to no utility with respect to tools like resume parsing programs. And accommodations that might be available and useful on a job itself to facilitate performance of an essential job function might not be available or useful for completing a personality or aptitude test. And individuals may not know that tools are being used, which makes it nearly impossible to request accommodations in the first place. And with that, I'll turn it over to Matt.
Thank you, Ariana. It's also often unclear to candidates how the tools affect the ultimate employment decision. Workers are not always told prior to a tool's use how the tool will evaluate them, which makes it incredibly difficult to anticipate how the tool could produce adverse results based on how the tool treats different marginalized identities. Finally, employers and vendors rarely subject selection procedures to rigorous auditing, and they rely on outdated and inadequate methods to determine whether a selection procedure discriminates. So now that you have some background on the reasons modern selection tools can be problematic, we're going to spend a few minutes discussing the substance of the civil rights standards and how the standards address the civil rights risks that modern selection tools can pose. The civil rights standards build on the 5 civil rights principles for hiring assessment technologies that civil society organizations developed in 2020. Those principles state that the use of hiring technologies should ensure non-discrimination, notice and explanation, job relatedness, auditing, and oversight and accountability. The civil rights standards promote non-discrimination by requiring employers and vendors to take proactive steps to minimize potential causes of discriminatory outcomes in their selection tools, use the least discriminatory tools available, and explore accommodations and more accessible alternative selection methods. The standards recommend banning the use of more arbitrary selection tools like facial or voice analysis or personality assessment, which pose a greater risk of discriminatory outcomes.
One of the major issues with many modern selection tools, again, is that candidates don't receive critical information on what traits these tools measure, how the tools measure those traits, and how the results of the tools are used in the decision-making process. Again, this is why in some cases, particularly with tools that use artificial intelligence, candidates are not even aware when tools are being used to assess them, and they're unable to ask for accommodations as a result. To address these challenges, the standards require notice and explanation through 3 tiers of notice tailored to the needs of different audiences. First, employers and vendors should proactively provide short-term disclosure to workers that offers enough detail to help workers discern how the selection method in question would assess them and whether to exercise their right to accommodations. Second, we recommend a more technical audit summary that provides regulators with enough detail to support oversight and enforcement efforts. Third, our proposed record-keeping obligations would have employers retain all relevant information about the selection methods that they use to support future investigation and enforcement.
The standards call for job relatedness by requiring that selection tools are restricted to measuring a worker's ability to perform essential functions of the job position for which that worker is being considered. Here, the standards push employers and vendors to think beyond the uniform guidelines, which Ariana described, to make sure selection methods are actually designed and developed to reliably assess whether workers can perform that job, rather than judging them on irrelevant, generic, or subjective traits. To achieve this, the standards state that the essential functions of a job must be established by objective evidence of what workers actually do in a job on a day-to-day basis. Employer-created documents such as job descriptions are not considered objective evidence because they may not reflect what workers are actually expected to do in a job in practice. Selection procedures must also be valid. An employer must show that the selection procedure actually measures the essential job functions it purports to measure. Employers should also explain why their tool should logically be expected to predict job performance, rather than relying exclusively on the existence of correlations between the results of a selection tool and often flawed measures of job performance.
The standards also articulate detailed auditing requirements that would more effectively examine biases in employer selection methods and results. Pre-deployment audits performed prior to deploying a selection tool would evaluate how well the tool measures actual ability to perform essential functions, identify risks of discrimination, and analyze whether any accommodations or alternative methods should be made available. The standards also recommend ongoing audits at least annually to re-examine these factors based on how the tool has impacted real workers, as well as any changes that have been made to the tool since the previous audit.
Finally, the standards call for more forceful oversight and accountability by explicitly recognizing that selection tools, whether automated or not, are unlawful if they cause discrimination. The standards also require both employers and vendors to take responsibility for preventing tech-driven discrimination, and they call for truly independent auditors who are accountable for audit results. Further, the standards recommend that employers support interactive dialogue with candidates, enabling workers to convey concerns about how a selection method will affect them so that employers can provide accommodation or alternative selection methods in the immediate term and examine how to alleviate these concerns for future candidates. So that is an overview of the civil rights standards. We now have some time for Q&A. And like Ariana said, there's a couple of ways that you can submit questions. You can use the Q&A function, which should be available to you at the bottom of your Zoom app. Or alternatively, you can send questions to questions@cdt.org, and they will get forwarded to us here. So I'll get us started with a question, and this one is directed to Henry. Henry, if I recall correctly, you actually had the opportunity to take a few gamified AI assessments and see how they work in practice. So could you share some of your observations and insights from that experience?
Matt, just to be really candid, it was pretty horrible. I had never taken an online timed test before, and which would be odd. You would think someone of 60 years might have run across this, but I really hadn't. And the anxiety that came along with that may have been triggered a little bit by some of the PTSD that I live with as a result of a spinal cord injury some 40 years ago. But the anxiety was really pronounced, and I could tell it was affecting how I could read the questions when they were presented to me, how I processed the information on the screen. And then the other issue that I was really noticeable was when I was required to do data input, I use my left hand predominantly to manipulate the keyboard, use the mouse and type data. Or type into the computer. And the amount of time that was taken just making sure that I was getting the mouse on the right place to click. And then when I was typing, the time typing with one hand, going back, addressing the errors, that the time was just eaten up with doing simple things like that. So I felt pretty bad about my performance. I know it was kind of an outlier and not a good measure of what I was capable of. But the demoralization that I felt, I think, was really one of the things that was most concerning to me. That somebody new, perhaps, to looking for work might be subject to this and then have to encounter these barriers really horrified me and motivated me to get into the work that we're doing. So thanks for the question, Matt.
I'll actually add, this is something that I recently had the opportunity to do a bit myself. So there's actually a few websites where individuals can go and take automated assessments and other sorts of assessments that employers frequently offer, such as personality assessments. So I signed up for one of those, and actually just last week went through some of those assessments. And I also had my wife, who is neurotypical and doesn't have any disabilities, and my daughter, who is autistic, go through some of the assessments as well. And I'll share a couple of my insights from those. Number one, the only accommodation, at least that this practice website offered, was additional time. There was no other option for people who are visually impaired, or people who are deaf or hard of hearing, or who have any other sorts of disabilities that may impact their ability to access and use the site. There was no other offer for accommodation. There was simply a single question at the beginning saying, if you believe you have a disability that may impact your ability to take this test, check here and you will be given 25% additional time to complete each assessment. From what I understand, that is actually fairly common for a lot of these assessments, that the only accommodation that is offered is additional time, or at least that's the only accommodation that is built into these assessments at the outset. The other thing I noticed, one of the assessments, and this is a fairly common assessment that is offered by employers, ask people to recognize emotions by looking at the photographs of faces of different people. Now, immediately, there are some problematic things about that, such as when you look at people's faces, what emotion they're displaying can definitely be influenced by cultural factors, aside from any sort of disability or accommodation and accessibility requirements. On those questions, my daughter, who I mentioned is autistic, got only 1 out of the 10 that she was asked to complete correct. My wife and I both took it and performed better, but both of us actually also got a majority of the questions wrong, which just kind of goes to show that, number one, these tools don't seem to be all that accurate to begin with. But number two, they are particularly challenging for people who maybe are neurodivergent and who have more difficulty deciphering what is considered kind of culturally normal facial expressions. So for folks who are interested, you can Google. There are a bunch of different websites that allow you to take these practice assessments, and you can experience for yourself at least a taste of what these are like.
Matt, if I can chime in, this is Alex. One of the other things that that I worry about the most is that often it's actually hard to know how the test is measuring you, to know if you're going to have an issue. And this is something that you both talked about in your remarks as well. I think about a very famous example of this. The reporter Hilke Schellman for the MIT Technology Review did a video interview for an English language company, and she completed the entire interview in the German language. It has scored her a 7 out of 10 for her proficiency. And when she tried to find out what had happened, she's an investigative reporter, and so she did her diligence, tried calling the company. She ultimately found one of the people that had helped design the test and said, well, how on earth did I get a 7 out of 10, match for this company if I literally answered every single question in the wrong language? And they said, well, actually, that test wasn't parsing your words per se. It was responding to your vocal intonation. That's really troubling, right? So number one, how would you even know if that's going to be an issue, if the tone of your voice might end up impacting on the results? I also wonder if the employer themselves know exactly how that test is working and what it's evaluating people for. So that's one of the reasons, just to underscore why we push so hard on this transparency piece. We have to know how these tools are actually designed and what they're measuring for people to know if they need an accommodation in the first place. And of course, let's move out of the disability frame for a moment and think about just the snake oil frame here, right? Like, is this test even logically, does it even make sense? And is it something that should be sold in the market?
And just one last item here. There's one test that Pymetrics, which is one of the larger and more prominent vendors of automated gamified assessments, offers, where the goal or the way that the game works is that you inflate a balloon, you click your mouse to inflate a balloon that appears on the screen for you. And at some point the balloon pops, and you're supposed to, every time you inflate the balloon, you collect more tokens. But if you click it too many times, the balloon will pop. And it's different each time how many clicks it'll take for the balloon to pop. So you kind of have to guess how many times you can click before it's going to explode. And if it explodes, you lose all your tokens that you would have gotten from that balloon. So it kind of is supposed to measure your risk taking, is the obvious thing. But Pymetrics claims that this can tell you about much more than risk taking. It claims that it can tell you about your ability to communicate and interact with others, and a bunch of other personality traits that don't seem to have any obvious relationship to clicking on a balloon and collecting tokens. So again, kind of pushing the snake oil part of it. And also it makes you wonder what inferences they are drawing and what sorts of assumptions, which have to be based on, again, kind of some idea of what is normal risk-taking behavior. It goes into deciding how candidates are evaluated using the tool. So lots of issues that folks who have seen or actually used these tools can run into. But next, I'd actually like to move on to another question. So what are some of the things, and this is a question for all of the panelists, what are some of the things you think disabled workers should do today if they encounter a selection test or tool that is inaccessible or that they think may discriminate against them?
So I'll start off on that. So I think that the first thing to do would just be to document as much as possible. I always find that having that documentation can only be helpful. So you can sort of, even if it's just you write down, what the test was, when you took it, how it worked. Another thing, if you feel comfortable, could be to disclose to the potential employer that you have a disability and to request an accommodation for the test or the tool, or to request alternative testing. Sometimes employers simply aren't aware of some of the issues that we've spoken about here today. They may not be thinking at all about how these tools impact someone with a disability. If you don't feel comfortable disclosing, you could consider finding an advocacy organization that could help. they also may be able to help you with, giving notice to the employer if you don't want to do it personally. They may be able to help you with ultimately filing a complaint with the EEOC or a legal complaint. But for all of those things, I think that the first step is, taking note of it, but also documenting as much as possible, so that you can have that either when you go to an employer, when you go to an advocacy org, or whatever your next step may be.
Thanks, Ariana. Any other thoughts from the other panelists? Okay. I'll move on to a slightly different question. So what can advocates for disabled workers do to help improve the fairness and accountability of modern selection tools? And Alex, do you want to start us off on that one?
Yeah, it's a great question, particularly given some of the folks whose names I recognize in the audience. So I'll jump in, and then Henry would love for you to chime in on this one too. One, I think we are in an AI moment. You cannot open the newspaper, particularly political-oriented newsletters, without coming across regulators, policymakers focusing on how AI is impacting society. A lot of that is being caused by the recent focus on ChatGPT, which has now sparked a whole conversation around killer robots and how AI is going to escape humanity. We are working really hard to capture that energy around AI to say the use of algorithmic systems for hiring is a very concrete example of how AI is impacting people's lives and their rights today, and how regulators can act. So advocates, this is a call-in. You are more than welcome, and indeed very much desired, to see how much we can leverage this moment to get policymakers to pay attention. We teed up some of this in the course of the earlier discussion. So the Biden administration, from the White House down, has been very focused on this issue. When they published the blueprint for an AI Bill of Rights last year, the use of AI in hiring was one of the fact patterns that they spelled out and spent real time on. They focused on disability issues in that document. We need to use that and have the White House keep paying attention to this issue and keep lifting it up. In addition, the Equal Employment Opportunity Commission and the Department of Justice have both been focused on this issue too, including the nexus to the Americans with Disabilities Act. But the more that we can kind of have them keep focusing on this, we need detailed guidance. We need them out there on the road talking every day to employers saying, you may well be breaking the law if you aren't asking the right questions about these tools and who they impact. So that employers start really standing up and paying attention. And frankly, we need them to start bringing enforcement actions too, to actually put their money where their mouth is and have vendors and employers start paying attention. So that's the executive branch. The next place that we are really pushing in our advocacy is Capitol Hill. So Senator Schumer, as the majority leader in the Senate, has talked about wanting the Senate to pass AI legislation. We are there saying, great, there are very real things that you can do now to make sure and make it easier for us to enforce our existing employment discrimination laws and the ADA, which we all know can actually be hard to enforce in practice. So there we're pushing for things like mandatory algorithmic transparency, some of the notice language that we've talked about already. So whether it's an AI, like a general AI bill, or specific legislation around the use of AI in the workplace in general, there's real energy that we could push for there too. And that can be both at the leadership level and the relevant committees of jurisdiction too. So the HELP committee, for example, in the Senate. So talking to Congress about it. If this isn't your day job and you don't feel like going to knock on the doors of Capitol Hill yourself, my goodness, come join us. CDT is deep in this work. There are a number of different organizations that are deep in this work. AAPD is out there doing this. And we would love to have more people signing on to letters, talking to Hill offices and the administration about this effort. The last thing I'll say is that if you're more of a grassroots organization or you just have a following in your own individual capacity, we need to do more to raise public awareness about these issues. One, simply to help people vindicate their rights, to know that these might be an issue when they're taking a test. There might be a reason why they're not getting a call back, and it might be an illegal reason that they're not getting a call back. So raising people's awareness about these potential harms is one big piece of this. And then, it's a really big issue that I think employers aren't thinking about these risks. I think for a lot of them, we are noticing them buying these tools because they are efficient and time-saving. Oftentimes, it's a pretty quick decision that's being made, not always with kind of the full analysis of what the downstream consequences might be. And I don't think they're often paying that much attention to the design with the type of lens that we as advocates have, right? Which is, what are the potential risks? How could discrimination come up here? And so we need to have employers paying attention to the negative effects of these tools. We need to have them asking hard questions of the vendors and really, again, using the market to drive attention here. So I think that's another area where this is just your Twitter following or your personal following or your grassroots org. The more you can help sound the alarm about these tools, the better, to help people, again, know their rights and have employers feel that call to action from the broader public that they need to take these harms seriously and be really careful in the tools that they use and deploy.
Thanks, Alex. And I'll add a couple of things, although one thing I want to quickly note, it looks like we lost Henry Claypool. I think he might have been experiencing technical difficulties. Hopefully he'll hop back on before the end. But just to kind of follow on Alex's points and kind of a cautionary tale that CDT had a front row seat to over the past couple of years. The New York City recently recently, actually just on July 1st, the first law of its kind that purports to regulate AI-based selection tools went into effect in New York City. And that law does not cover disability discrimination. That law initially kind of was vaguely written, but it was written in a way that said that employers had to check for all types of discriminatory outcomes and discriminatory actions that in the course of selection processes. But the final version that was rammed through kind of very opaquely, in a very hidden way, made it so that when employers have to do what the law calls a bias audit, they only have to check for adverse impact based on race, sex, and national origin. And disability was effectively, as a result, written out of the law. We tried to raise concerns before the final version of the law passed through on why it's important to have disability included as a focus of the law. That was largely disregarded. It was completely disregarded, actually, in the final version of it. But, and we have no way of knowing whether increased engagement from disabled workers advocates would have ultimately made a difference in New York City, but it certainly couldn't have hurt. And what is certainly true is that if organizations that care about the ways in which these tools impact disabled workers do not engage with policymakers, I think it is clear that in that case, these laws certainly will not reflect the needs and the legal rights that disabled workers enjoy. So it's really important, especially as the New York City law is kind of being elevated in the press as a possible example for other states and cities to follow, for groups and individuals who care about disabled workers' participation in the workforce to get and stay engaged on these issues so that good accountability and good policymaking can come to fruition. So at this point, it doesn't look like we have any other questions on tap. I was going to have Henry give a couple of minutes of closing remarks. Since we've lost him, I'll just wrap us up by saying thank you to all of the participants in today's webinar. On behalf of the organizations that created the civil rights standards, which are CDT, the ACLU, the American Association with People with Disabilities, the Leadership Conference for Civil and Human Rights, Upturn, and the National Women's Law Center. We have representatives from a couple of those organizations I see in attendance today. So thank you on behalf of all of us to the participants today and to our audience. And we'd like to also thank some of the folks who helped draft the standards that are not parts of those organizations, namely Aaron Reiki, Amalia Smirnotopoulos, Chai Feldblum, Clarence Oko, Katura Tops, and Sarah David Heidemann. They gave valuable feedback in the course of the creation of these standards. And all the other organizations and individuals who kind of have helped elevate the standards and who gave us feedback in the course of the drafting process. So you can read the civil rights standards on our CDT's website. I believe that the invitation that you received in your email inbox actually includes a link to the civil rights standards, so we would encourage you to review them there. We hope that the civil rights standards are going to help shape industry and policymakers' thinking and help inform advocates' efforts in ensuring that this conversation continues. So we encourage you to reach out to us to talk further about the civil rights standards, as well as your perspective on modern decision-making processes and how we can get the standards to be used to decrease algorithmic bias. So thank you very much to everyone. Hope everyone had a great holiday shortened week, and we hope to hear from you very soon. Thank you.